Well, hello, and thank you for joining us today. I am Roy Harriman with Ministry Pacific, and our topic for today's webinar is the importance of church bylaws. What are they? Why do they matter? How often should you review them? This webinar, by the way, is a service to our clients as well as to all guests of the webinar. Ministry Pacific is a property and liability insurance broker for churches and charitable nonprofit organizations, and we're here to serve you. Our guest and subject matter expert is Max Herr, who I will defer to in just a moment. A little bit more about our subject. Many churches' bylaws are seldom referenced and rarely reviewed. And while all may seem quiet, circumstances from within and without may test your bylaws. And if that happens, the question is, will the bylaws stand? And ultimately, will your church stand? Max, our guest, forwarded me a very recent development that confirms the importance of this subject. Unfortunately, one of the largest churches in Arkansas is undergoing conflict regarding its senior pastor. And the congregation appears to be split about 50-50 over whether the pastor should go or stay. In the midst of this debate, the fact emerged that this 132-year-old church has no corporate charter, constitution, or bylaws. Could this be you? Max Herr is president of Church and Ministry Compliance Consulting, and he's been an excellent resource for Ministry Pacific and our clients. He has more than 25 years of experience in insurance, financial services, compliance, and governance, including more than 10 years as a church treasurer. Max also served as a church compliance specialist for the California Southern Baptist Convention for 6 years. Welcome, Max, and the microphone is yours.
Good morning, all. I'm going to go ahead and share my screen. The presentation I've titled it Governance Through Bylaws. The subtitle is really the important part of preparing a set of bylaws. I use the words intentionality a lot. The forward-thinking folks who work on a set of bylaws need to anticipate future needs because they're fundamental components of congregationally governed churches and their bylaws. Your church may have a slightly different form of governance, such as elder rule or elder-led, and I do have sets of model bylaws to cover those types of situations. I think the majority of churches that I deal with are congregationally governed, and so that's going to be the focus of this presentation as we go today. The importance of bylaws is your church, if it's incorporated, as it should be, is subject to the state's corporations code. And usually there's a section within the corporations code that's directed to religious nonprofit corporations. If you don't have a set of bylaws, you are stuck with all of those regulations and laws that the state has written for those types of organizations. But when you read the corporations code, it will say, unless the bylaws say otherwise, this is what must be true. And so that's why it's critical for every church to have its own set of bylaws in order to not be subject to all of the mandates of the state. Now, there are certain things that the state does require that the church can't overlook, like having a board of directors, one of the critical elements of church governance. You can't legislate away from that. But having a good set of bylaws will get you over the strictures. So most corporations codes recognize the articles of incorporation as a constitution. The Constitution really is an archaic term when it's applied to churches. Articles of incorporation is the birth certificate of the person of the church corporation. Your articles of incorporation are one of several permanent record documents of the church, along with a copy of your IRS taxpayer identification number. And if you've applied for one and have received a determination letter from the IRS, that's another permanent record. Your bylaws, in essence, are also a permanent record of the church. One of the hard things for churches to understand is that they actually are a little schizophrenic. They have two distinct personalities. And those personalities are dependent or interdependent on one another. Everybody who's a member of the church, who attends church, recognizes that the church has a spiritual element or person to it. But too many folks, especially church pastors or ministers, they fail to understand or want to ignore in many cases, the fact that the church is also a civil person. And that's the corporate nature of the church. You've been granted that charter, you've filed those articles of incorporation with the state, and that creates a civil person, a non-natural person. Bylaws are known as a guiding document. Your articles of incorporation have a few little bits of guiding statements in them, just enough to establish that person of the church. But what you really need is a set of bylaws that discuss how the church conducts its business affairs, not so much the religious side, but the business side. And just as churches change, evolve with time, bylaws are not intended to be a static document. They are dynamic. And as the church grows, as the church matures, as the church changes, the bylaws need to keep up with that. And unfortunately, some churches wrote their bylaws 20, 30, 40 years ago. They've never looked at them again. And that's very unfortunate. Like machinery, bylaws do require periodic maintenance. Those reviews, the updates, those things should happen on a regular schedule, at least every 2 years or so. Somebody needs to look at the bylaws, go through them, make sure that they're still relevant. The reason for that is your bylaws have to be followed explicitly. If it says the church shall do this, or someone in the church shall do this, there's no escape from that. It's a mandatory thing. On the other hand, if it says the church may do this, it gives the church some flexibility. And that's the reason why when I review a set of bylaws, if I see the word shall being used too much, I recommend that many of those shalls be changed to may to be able to offer flexibility. How do you anticipate unplanned needs? Well, let's say you have a church of 50 attendees on Sunday, a very small church, and you don't really have a children's program. You can still write into your bylaws the functioning of a children's program or the leadership of a children's program with the statement, the church may do these things, and be ready to do those things when the time comes. Same thing with trustees. You probably need a group of people known as trustees to hold title to the church property. The church as a person doesn't have the ability to sign documents, so you need somebody who can do those things. And trustees are normally the group of folks that hold title and make decisions about church property with guidance from the church. Maybe you don't own your own facility today, and so you don't necessarily need a group of trustees today. But you can write into your bylaws, the church may establish a board of trustees at the time that it owns property. And then you don't have to rewrite your bylaws at that same point in time. Creating or amending bylaws, I believe, truly must be a deliberate and intentional process. There's no universal set of bylaws, but I've seen churches that have used a set of bylaws that they've taken from another church, and it doesn't necessarily reflect how the church really wants to operate, but nobody's ever really taken a look at the wording in the bylaws, and they just have it and say, well, these are our bylaws. When I work with a church on crafting its bylaws, I want to help them understand that the personality of their church is unique, and it's that personality that must be the controlling factor behind the bylaws. And a very important aspect of bylaws is this third point. The bylaws have to differentiate between governance and doctrine. You don't want to put a lot of doctrinal stuff into your bylaws, because your bylaws are not about doctrine. They're about the governance, how the church does its business, how the church operates. In many cases, it's reflective of church doctrine, but you don't want to make statements of doctrine in your bylaws because they're not normally statements of governance. What's very important to understand is bylaws are strictly an internal document. There is no requirement for bylaws to be filed with any government agency. They're not required to be signed. They're not required to be notarized. Doing those things doesn't add any weight or legality to the bylaws, as long as you have a statement. And I usually encourage churches to put it on the very first page. These are the bylaws of XYZ church, and they were approved by the vote of the congregation on thus and such a date. Very first thing you read. That's sufficient to establish the validity, the veracity of the bylaws. On the other hand, you may be asked to submit a copy of your bylaws to your bank so that they know who has legal authority to transact business. You may have to submit a copy of your bylaws for various benefits, such as obtaining an IRS determination letter or applying for grants or other funding. And again, the purpose is not to find out how the church does things, but to make sure the church has a set of rules that establishes authorities and powers so that the organization or the entity knows who has the authority to do business. I talk about a thing called historicity of the bylaws. You always want to have your clean and dated copy of the current set on file. If somebody comes to the church new, you want to give them a copy of the current bylaws so that they know how the church operates. It's very important if you're searching for a new minister, a new pastor, that individual get a copy of your bylaws so that they know what kind of situation they're stepping into. You should never make handwritten changes on the official set of bylaws. I've seen this a number of times, and it's a very bad practice because many times they're not dated, or sometimes there's multiple handwritten changes with various dates, and that's even worse because you go back to the church minutes and you don't find any record of this action being taken. Very, very bad practice. Don't append changes or additions to the current document. If you make changes to the bylaws, you simply create a new clean and dated copy so that you always have that clean and dated copy that's the most accurate, most up to date. You want to keep all prior sets of bylaws. This is the historicity for historical reference. In some cases, somebody might be attacking the church based on an old set of bylaws. And that's okay. But if you have a newer set of bylaws, you can drag out both the old set and the new set and show when a change was made and how it was approved and when it took effect. Another important factor of having the past sets of bylaws is that you can compare them, old to new, to prevent conflict of interpretation. It also is probably a very good idea to create a separate written document that narrates the events that led up to or caused a complete rewrite or major overhaul of the bylaws. This was true in my former church. After a major conflict, we found it necessary to write an entirely new set of bylaws. And I served as the chairman of that bylaws committee back in 2006, 2007. And I wrote a narrative that explained why we wrote certain provisions into those bylaws, because the new bylaws were very different than the former bylaws. Just think of it in terms of our own United States Constitution. It was written almost 250 years ago. The original authors are long gone. And look at the conflict we have over things such as the First and Second Amendments. We don't have a narrative exactly that says, why did we write these words? You have the Federalist Papers that try and explain some of the reasoning behind those things, but they're not necessarily authoritative, as opposed to the original authors sitting down and writing down, here's what we meant when we said freedom of religion, freedom of speech, freedom of the press. This is exactly what we meant, so that nobody has to interpret it 200 years later. The bylaws of a church explain how it's going to conduct its civil, or sometimes you see the word temporal affairs, the internal affairs of the church. The spiritual matters, they're important, but they're a minor component of bylaws, because your bylaws are not intended to lay out your doctrine. They're not intended to discuss spiritual matters. Those things are better handled in a policy and procedures manual. And we're going to talk about the relationship of those two documents. The biggest weakness, or the most common weakness that I find in bylaws, is the failure to properly articulate powers and authorities within that civil nature of the church. You have church officers, you have corporate officers, and the two might be different. In the Baptist context, most Baptist polity says that the officers of the church are the pastor and the deacons. But on the corporate side, the officers of the church are a president, a secretary, and a treasurer. And so the bylaws, they will have to articulate the powers and authorities of the president, the secretary, and the treasurer. But in recognition of the spiritual officers of the church, there also needs to be a little discussion of the role of the pastor, or the role of the deacons, or others who have spiritual leadership over the church. You can learn from government examples. You can learn bad examples, and you can learn good examples. Just as laws empower action, separately written administrative regulations define how those laws are implemented and enforced. Roy mentioned that I have a long-standing career in insurance. And we have in California and in other states, we have the insurance code. And the insurance code enables the commissioner to enforce these laws. But in many cases, a section of the insurance code says the commissioner will create regulations that are designed to demonstrate how this law will be implemented, or how this law will be enforced. And the laws are analogous to your bylaws. They're authorized by votes. The laws are enacted by the legislature, or in California and other states, they can be enacted by the people through the referendum initiative process. But the regulations that are in a different set of legal books, in California is called the California Code of Regulations, that's analogous to your policy and procedures manual. So you have the bylaws that says this is what we're going to do. Then you have the policies and procedures in a separate document that says this is how we do those things. The importance of having both is that while it takes a vote to change your bylaws, it doesn't necessarily require a vote to change policies and procedures. Normally, you put the policies and procedures in the hands of another group for approval. And when that group approves a change in policy or writes a new policy, they simply notify everybody, this is the new policy. If you don't like the policy, you can petition for change, or you can vote with your feet and go someplace else where the policies are more to your liking. The word that I like to use about policies and procedures is they are an adjunct or a companion governing document. They don't have the same weight as the bylaws or the articles of incorporation, but they are number 3 in the list of things that guide the church. The best practice is to make an explicit reference to the authority of policies and procedures as that adjunct document. One of the reasons for that is, it's coming up on another slide, your bylaws really only become a public document if somebody sues you over the conduct of the church relative to its bylaws. At that time, it may be important to bring the policies and procedures along into that court case or arbitration. But if you haven't made reference to the fact that you have policies and procedures, it could be problematic trying to introduce it as evidence. So by having a specific reference to policies and procedures multiple times in your bylaws, it makes it clear to whoever is adjudicating a matter that we better take a look at those policies and procedures as well. Policies and procedures, by the way, have to be written. They should be written with detail. They're not necessary specifically for governance, but they do empower flexibility. Your bylaws, your policies and procedures, like I said, they're not public documents, but they're not confidential documents either. Anybody that's a member of your church or an attender of your church should have the right to see a copy or have a copy of the bylaws, have a copy of policies and procedures. They will definitely become public documents in the event of a lawsuit. The purpose, again, is to identify what the church is supposed to be doing. It will explain what the church should have done if it didn't do it, or what the church absolutely failed to do. Many times when I get a phone call from a church asking how to deal with a particular situation, my natural question is, well, what does your policy and procedures manual have to say about this? Do you have a written policy for it? And frequently I hear on the other side of the phone call, well, everybody knows what the policy is. We just don't have it in writing. A long time ago, I started using this phrase. If you don't have written policies and procedures, what you have are simply pleasant thoughts, because you can ask 10 different people what the policy is, and you could get 9 or 10 or 20 different interpretations. If it's in writing, now you have it established. If it's not in writing, you have no way to prove what the policy is. Structure is very important to bylaws. Many bylaws sets that I review suffer from a lack of structure, or they're disorganized. And especially when they're disorganized, it's probably insufficient in content. Having a structure is not based on the importance of one article above another. In fact, I try and show churches to put a footnote on the very first page that says the order of these bylaws doesn't indicate the superiority of one over another. It's just the way we've put them together. But they should follow a logical progression. If Article 1 is the formation of the church, the name of this corporation is ABC Evangelical Church, the very last thing, or very near to the end, should be what happens if the church goes out of business, if we dissolve the church. It should not be the second thing. We establish the church, here's how we get rid of the church. That's just not logical. Having a standard form, a structural form, normally you want to use an outline type of format rather than a narrative. A narrative, people get lost in the words. An outline, more compact or more orderly. And if it's orderly, it makes it easier to read, easier to understand. You should be able to find what you're looking for without much trouble. If you're looking for something and you can't find it, the structure will help you understand that we're missing something that we need. The formal structure identifies weaknesses. When thoughts are well organized, those things that are missing become more obvious. Saying less is sometimes better, not always, but saying too much is often much worse. The statement here, well use of English grammar, is a key component. Now, anybody who speaks English ought to look at that and say, that doesn't sound very good, well use of English grammar. Here's a better way to say it. Using English grammar well is a key component. Don't try to impress folks with legalese. Overworking the word shall in light of the word may, those two words don't carry the same weight. And when you use shall too much, you can cause the church to be confined rather than flexible. Another statement, incomplete sentences frequently. Frequently what? Well, they lead to confusion. Incomplete sentences lead to confusion because we don't know what the end of the sentence is supposed to say. And I have an example of that. It's best to say exactly what you mean. Discerning the correct meaning of vague statements is nearly impossible. And ambiguous statements are even worse because they can be read in more ways than one, and each one sounds reasonable. And I do expert witness work in the realm of insurance, and sometimes insurance contracts are vague, and sometimes insurance contracts are ambiguous. And the law says this: if a contract is ambiguous and you can't tell which statement is the proper one, when two statements or when one statement is interpreted two different ways and each way sounds reasonable, the party that did not write the words of the contract, their interpretation is the one that the court goes with. So when you have ambiguous statements in your bylaws are contractual in nature. If you can't understand what it says, and there are two different ways to read it, whoever is reading it that didn't write it, their way is going to be the interpretation that the court goes with. And that could be very unfortunate for the church. So when I find ambiguities in bylaws, I try and point them out and indicate that you've got to resolve these ambiguities. But vague statements are just those things. Take a look at our Second Amendment and all of the controversy over that. I see this a lot, using Christianese and Bible references to articulate in bylaws what the church intends. That's very poor practice. Don't quote scripture and expect scripture to say to somebody else exactly what it is that you intend. There are passages of the Bible that are easily taken out of context that sound great. You put it on paper and try and operate with it, and it can create all kinds of problems. If you're trying to articulate, let's say, the duties of deacon, and the characteristics of a deacon are described by Paul in 1 Timothy chapter 3. What does it mean in today's language to say the husband of one wife? Is Paul talking about polygamy? Is Paul talking about a person who was divorced and remarried? You just get into too much trouble trying to articulate things strictly with a biblical reference. Instead, write the words that you want to use specifically. This next bullet point, it should stick out as a sore thumb. Pay attention to a semicolon, punctuation and spelling misspelled, especially misspelled, the use of, conjoined, symbols. Your word search might not recognize that as wrong. So what I try and show folks is pay attention to punctuation and spelling, especially the use of symbols and commas. Why? Because I read, as part of my expert witness work, I read appellate court opinions and Supreme Court opinions. And frequently, a case turns on the position of a comma. If a comma is missing, it means one thing. If the comma is there, it means something else. When I was at school at Cal Baptist way back in 1984, I wrote a biography of the incoming president of the college for the inauguration handbook. And after I wrote it, they had the head of the English department proofread my writing. And the one comment that he made was, "I sure wish my students knew how to use commas as well as you do." You want to eliminate parenthetical statements. I see parenthetical statements in bylaws frequently. Incorporate the thought in the grammar of the sentence. Don't put it in parentheses, because a parenthetical statement is like an afterthought. We didn't write it, and now we're going to stick it in. It's better to write it so that it's not subject to interpretation. As I mentioned, your bylaws are contractual in nature. The church is indicating how it's going to handle its affairs. Bylaws are not intended to be a secret document. The corporation, its officers, its directors, employees to a certain extent, they're responsible for adhering to the bylaws. The members of an organization generally agree to be bound by the bylaws, And you should use reinforcing language such as a condition of membership. But if you say things like as a condition of membership, but you don't give anybody a copy of the document, they can legitimately say, I didn't know this was a condition of my membership. Nobody ever told me that. And you'll be found at fault for keeping your bylaws kind of a secret document. So don't treat your bylaws as a secret. Make sure everybody in the organization, in the church, has a copy of the bylaws. Anybody who violates the bylaws is an offender, and it subjects the offender to a number of possible consequences. The church itself, as a corporation, can be sued by its members for violating the bylaws. Officers and directors could potentially be held personally or financially responsible for not adhering to their what's called fiduciary responsibility to the corporation. Members can be disciplined. Many churches have a formal disciplinary process. And if you do, it needs to be articulated in your bylaws. There are a number of things that I believe are essential to a good set of bylaws. First, use appropriate, very simple titles for each article. 2 or 3 words in most cases is sufficient. It's very important to avoid combining unrelated items under a single article. It creates confusion, and many times it indicates that you should have had a different article to handle a particular topic. It's not improper to use the he, she, or his, hers pronouns as you write bylaws, but you can avoid that. You can simply put a footnote at the bottom of the very first page. We use he or him without regard to gender. It's just for convenience so that we don't have to have all of these dual or binary pronouns throughout the document. Determine which doctrinal elements are essential for bylaws. Put all others into the policy and procedures manual. Very early on in your bylaws, you're going to need something called a statement of faith or a statement of purpose and faith. And you'll make some of those doctrinal statements there, but it doesn't have to be 15 or 20 or 30 different items. It just needs to be a very concise statement and then a reference to the full statement in your policies and procedures. You definitely want to omit anything that's not governance. Statements that are opinions or narratives. Why did we write this section? It doesn't belong in your bylaws. Bylaws need to be concise. I see this sometimes in the opening statement, the name of the church. The name of this corporation is First Evangelical Free Church of Pomona. And then it goes on to say, we have a DBA of thus and so. You don't want that. There's no reason to make a statement of a DBA in your bylaws. The bylaws don't impact the DBA. DBA simply means doing business as. It's an alternate name for the church. You can't create a DBA in your bylaws. A DBA you have to create legally through the county clerk's office. You need a statement as to the principal office. Where is the principal office located? You're not going to use the address of the UPS store where your mailbox is. That's not where anybody can come and find your corporate records. So you have to have a principal office location. Statements of purpose and faith, polity and relationships. How do we conduct our religious affairs within our denomination, perhaps, or in relation to other churches or other organizations? Another common flaw in bylaws is when you talk about membership in the church. If your church has members, you have to describe what the essential requirements are to be a member. If you have members, you need to define the difference between active and inactive members, because you probably want to limit voting on church business to those folks who are active members. sometimes I see in bylaws, especially in churches that are rural in character, they talk about an active member has to live within so many miles of the church. That may or may not be a best practice. It depends on the church, but it certainly is a better statement than just saying all members of the church have the right to vote. If somebody has moved 400 miles away and they're not participating in the church, why should they have the right to vote on a church matter? If your membership can be transferred to another church of the same denomination, or someone leaves your church and they go to another church that wants a letter of recommendation, how do we provide that? Or how do we terminate a person's membership? What's the process for that? Don't overlook church discipline in your bylaws. If you have members, it's scriptural to have a discussion of church discipline, but you just don't want to say church discipline is based on Matthew 18, 15 through 21. It's not entirely descriptive of your process for discipline. Meetings, very critical part of bylaws and sometimes not well defined. Your meetings require notices in advance. Your meetings require a quorum to conduct business. Your meetings are supposed to operate according to some form of procedure. We like to call it parliamentary procedure. Your meetings, there should be a right to vote. If you have members in your church, how is that right to vote established? Your bylaws should articulate that you conduct two types of meetings. You have worship meetings and you have business meetings. Functionally, you never want to combine business with worship. You don't want to say at the end of the Sunday service, we're going to take a vote on this, that, or the other during the worship service. You can have that business meeting after the worship service, and you can announce during the worship service that the business meeting will be held following the close of worship. But you don't take those business votes during worship. And there's good reason for that. If you confine your business meetings to your active members, you don't allow non-members to attend your meeting, whatever is said during that business meeting is confidential in nature. If one of your members takes that confidential statement into the outside world, they can be disciplined for that according to your process. But if you conduct business during worship, that's a public situation. And if things get heated in a discussion before a vote, all that stuff that's being said is being said in public, and it can get lots of folks in big trouble. So don't combine business and worship, and make sure you state that in a variety of ways in your bylaws. Churches have what are called program organizations. You have your Sunday school program, you have small groups, you have children's ministries, women's ministries, homeless ministries. All these things are known as program organizations. In your bylaws, I've seen churches try and list all of the different program organizations. It's not the best practice. What's best practice in bylaws is to empower the church to create program organizations, and you can make a simple statement such as, the church may maintain programs such as Sunday school, small groups, children's ministries, and others, but the complete list will be found in the Policy and Procedures Manual. And you use the Policy and Procedures Manual to define those organizations, how they operate, what their authorities are within the context of the bylaws. In your bylaws, you should have what's known as the IRC Section 501c3 compliance statement. It's probably in your articles of incorporation, but it's not a bad idea to reiterate it in your bylaws. How the corporation exists for nonprofit purposes, that the none of the assets will, in the technical term is inure, INURE, None of the assets will inure to the benefit of any private person or officer, director, or member of the church. A property dedication and dissolution clause. Again, these are IRC statements that our property is irrevocably dedicated to the church's exempt purposes. And in the event the church were to dissolve, that our assets will be used to pay off our debts, and anything remaining will go to another nonprofit organization. It's very critical to have that in your articles of incorporation, and you should also have it in your bylaws. Alternative dispute resolution, you might know it as mediation or arbitration. I believe that most churches would be better off to include something like this in their bylaws than not, because what it can say is, using those words, as a condition of membership, members will not involve the church in litigation through the civil courts, but we do have a mechanism established for Christian mediation or Christian arbitration. And there are several organizations that assist churches in that way, one of which, very well known, is called Peacemakers Ministry. And they have certified arbitrators and mediators who will help a church resolve a dispute or tension within the church if the parties are willing. What I do want to say about alternative dispute resolution is it's generally known as an administrative process. And in order to survive the scrutiny of the court, the parties have to observe every one of the administrative steps along the way. And that can be your rescue from a civil lawsuit in court, is the party that's suing the church failed to exhaust what are called their administrative remedies. And if it's clearly spelled out in your bylaws and your policy and procedures manual, that can be the saving grace that keeps you out of state or federal court over a problem with your bylaws. Another thing that churches don't often think about including in their bylaws is what's known as a severability statement. A severability statement simply says if any provision in these bylaws doesn't pass legal muster, that the whole bylaws don't get thrown out at the same time. The document can survive minus this statement or section. It's important to clearly state the roles, the powers, and the authorities, if any, that you're going to grant to your officers, your board of directors, your pastors, elders, deacons, your ministry team, other church officers or leaders, your trustees, your employees. Your church may operate with a church council. It may operate with committees. You want to establish the powers and authorities. Now, when it comes to committees, again, I don't recommend putting this long list of committees in your bylaws. Instead, you enable the fact that the church can create committees, and then you state that powers and authorities of those committees will be expressed in the policy and procedures manual. That way, if a committee goes out of business, you just pull that page out of the manual. If the current policy or procedures don't work and the committee wants to change those things, they can write new procedures, and then it goes to the church council or whomever has oversight approval of the policies. What's important to know about your bylaws, because they can't be changed without a vote of somebody or some group, those things that you intend to make difficult to change really do need to be addressed in bylaws. You don't put those things in policies and procedures alone. Things like the authority for borrowing money needs to be stated in the bylaws. Who has the authority? And that authority may be subject to the approval of the congregation, for example. Same thing with buying or selling property and amending the bylaws. How are amendments made? What's the procedure for that? Things that are optional. Most of these things are doctrinal in nature. They're not necessarily governance. They can be in bylaws, but from my perspective, many times they're better stated in policy and procedures rather than bylaws. You could include a discourse on church covenant. You could make statements about tithing. You can make statements about marriage and family and sexuality, But instead of spending 2 or 3 pages on these kinds of things, which is easy to do, it's better just to say, we'll find these things in the policy and procedures manual. So as we've talked about it, bylaws are like the skeleton of the body. They provide the structure. The policies and procedures are the muscles and the skin that goes over the top. It provides the flexibility. Good governance is a combination of both, a good set of bylaws and very well written and complete policies and procedures. One without the other is going to be insufficient. Those elements that are not essential to governance, but which church leaders or members believe are important for operational or spiritual reasons, those are the things that need to be in the personnel handbook or the members' code of conduct or the policy and procedures manual. You don't want to bog down your bylaws with stuff like this that's not essential. You make reference to it in your bylaws, but then you say, look here in this other place to find the important stuff. You want to use the bylaws to explicitly acknowledge that these things are important. The relationship to the church, the relationship to the employees or the members, but very clearly indicate where that information is going to be found. How does including non-essentials in bylaws impair church operations? Well, imagine this. You have a pastor description or staff descriptions in your bylaws, and then it says the compensation will be X, the benefits will be Y, and other things that are stated alongside that. If you come to a point in time that you can't afford those things, you're stuck with them if it says the pastor shall be given medical insurance for himself and his family. The law changed about that back in 2013, 2014, when the Affordable Care Act came into being. Churches for years, decades, had been giving pastors money to buy health insurance if they weren't providing it on their own, or they were reimbursing the pastor for his cost of health insurance. You can't do that today unless it's through a group health insurance plan or what's called an ICHRA, individual contribution health reimbursement arrangement. If you give the pastor money to pay for health insurance today, and it's not through one of those two other ways, it has to be counted as taxable income to the pastor. You don't want to be forced into that position if you can't afford it. Saying in your bylaws that there will be 2 services on Sunday and 1 service on Wednesday, and you're not having services on Wednesday, you're only having 1 service on Sunday, you're violating your bylaws. I've seen bylaws that have a list of 30 or 40 different committees in the church or program organizations. And my question is naturally, do you have all of these committees today? Well, if the answer is yes, they're not in violation of their bylaws. If the answer is no, they're in violation of their bylaws. So one of the two things has to change. We either have to get all those committees going again, or we have to revise the bylaws. So putting non-essentials like this into your bylaws can create more problems than they solve. Defining numbers of deacons or elders. The church will have X number of deacons based on 1 deacon for every 10 families. Well, that may be a reasonable number at some point in time, but it might not be a reasonable number later on. And now you're stuck having 1 deacon for every 10 families. Any statements in your bylaws that use the word procedure or process probably need to be omitted, because it's something that probably needs to be in the policy and procedures manual. Unless it's one of those things like church discipline, that's a very deliberate process. That kind of thing should be in bylaws, but other things probably better taken out. Anything not specific to church governance, things like the pastor will be the first person to the church to unlock all the doors and the last person to leave to make sure everything's locked up. That's not governance. That's just a job description or job duty. Doesn't need to be in bylaws. Think back 4 years ago to this point in time. Something came upon the churches across America, especially here in California. We were told the churches were not essential to public order. Marijuana dispensaries, liquor stores, they were essential to public order. Home Depot, Lowe's, they were essential to public order, but the mom and pop hardware stores weren't. Churches, more than any other organization type, they were forced to abandon regular worship services due to shelter-in-place orders. Now, there are some churches that chose not to obey those orders, and turned out that they, for standing their ground, they may have been fined along the way, but no church that I'm aware of here in California has ever paid a fine. Churches of all denominations suddenly discovered, though, that they were almost powerless to conduct official business meetings. And in a parliamentary guide like Robert's Rules of Order, business meetings are known as deliberative assemblies. It became a real problem for churches that needed to conduct business according to their bylaws, but couldn't. How do we have a business meeting when we can't be at the church? There's a definition of a deliberative assembly. The official business meetings of the church, its council, board of directors, etc. According to Robert's Rules of Order, this is the definition of a deliberate assembly: a single official gathering of its members in one room or area to transact business for a length of time during which there is no cessation of proceedings and the members do not separate unless for a short recess. We're having this assembly today via Zoom. Zoom is not the only platform for having an assembly, but in 2020, in February and March of 2020, Robert's Rules of Order did not allow for virtual business meetings. It was coming, and it came in September of 2020. They had already created new directives for electronic or virtual business meetings, but it wasn't officially allowed within the corporations code here in California either. It said the board of directors couldn't meet electronically, but it didn't say anything about members' meetings. So it's a real big problem, and consider a Zoom meeting like this. Are we in one room or area? We're not. I mean, some of you could be on the East Coast. Some of you could be up in Washington State. Many of you are here in California, but none of you are here in the room with me. None of you are here in the room with Roy in Missouri. So we are not all in one place to transact business. If your bylaws are silent on virtual board of directors meetings, the state law usually permits them, but certain notice requirements are required. Usually it says all board members must attend. Each must be able to hear and be heard by the others. There is no requirement to see or be seen. It's not a criteria. As I mentioned, state laws are usually much less certain when it comes to the ability of the members of a nonprofit organization to come together for a regular or special business meeting. And this is another one of those places where the corporation's code says, unless it's stated in the organization's bylaws, you can't do it. So the real problem that churches faced back in 2020 was the absence of specific guidance on virtual business meetings or virtual meetings. I don't know of any church that already had the foresight to include that in their bylaws. My church at the time, we didn't have that in our bylaws. And now we were stuck because we didn't have the ability to come together and amend the bylaws properly. When bylaws specify Robert's Rules of Order newly revised, which is the actual title, as the form of parliamentary procedure, those rules override any silence in the bylaws. So many church bylaws are deficient when it comes to parliamentary procedure. They don't name a specific form of parliamentary procedure. Robert's Rules is not the only form. There are many other forms. Some are far less technical than Robert's Rules. And when I was first introduced to Robert's Rules back in the mid 1960s, just after leaving the seventh grade, Robert's Rules was maybe 100 pages long. Today, Robert's Rules is about 900 pages long. That's just what happens over time as you make things more explicit, more complete. The board of directors in Robert's Rules is given greater latitude to meet and conduct business other than in-person forms. Many churches adopt Robert's Rules. The 11th edition, as I mentioned, which was approved or published in 2011, literally prohibited virtual members' meetings. They all had to be in-person meetings. The 12th edition that came out in September 2020 now permits virtual business meetings. But it's very important in your bylaws not to say we're governed under the 11th edition of Robert's Rules. And the way that you want to adopt Robert's Rules into your bylaws is simply to say the most current edition of Robert's Rules of Order, newly revised, is the official parliamentary authority of the church. That way, when the 13th edition comes out, you're not going to be forced to amend your bylaws from 12 to 13. You've got it covered with sort of a vague statement, but one that's more precise than not. If the language in the bylaws is incomplete or too specific or outdated, simply adopting Robert's Rules of Order is not going to be completely effective. If your statement in bylaws says the church adopts Robert's Rules of Order as a title, and it's as its official parliamentary guide for the conduct of business meetings, that phrase, Robert's Rules of Order, refers back to 1879 when it was first written, or the last edition under that title. It became Robert's Rules of Order newly revised later on in the 1900s. So you've got to be careful about the language that you use. And the proper term today would be Robert's Rules of Order newly revised. The 12th edition provides options for one or both of the two most common omissions in bylaws. No authority as a congregation to meet for business in an alternative forum or venue, and no authority for electronic or absentee voting. That was the other problem that many churches faced back in 2020 and may still face today if they haven't changed their bylaws, is they had no mechanism for absentee voting. All voting was to be done in person. Now we're totally stuck. We can't meet in person. We need to take a vote on something. We can't even take a vote. We had to be creative with some churches to say, well, you can have your meeting electronically, but you can't take a vote during the meeting. The people are going to have to come to the church to vote. And how you manage to do that is to have them drive up and drop off their ballot, I suppose. We had to get creative to work around some of these problems. But in some cases, another deficiency in bylaws was that the church had no articulated board of directors. So you don't even have a group that can authorize any of this stuff. Today, the bylaws of almost every church need to be modernized in one or more ways. In some cases, they need to be specific when it comes to authorizing alternative forms of meetings, board meetings, business meetings, committee meetings, and lay the foundation for how to give notice, how to provide voting rights, and what are the acceptable voting methods. The inadvertent use of language in your bylaws, if it's too restrictive, it impairs the church's ability to conduct meetings. You don't want to say the only way to do this is via Zoom. What if Zoom goes out of business or changes its name? GoToMeeting, Teams, Skype. These are all legitimate forms of alternative meeting solutions, but don't specify one. Especially don't specify by name. The bylaws probably fail to authorize any hybrid form of meeting. Notice is always required of meetings. The question is, how will it be given? If we can't be in church to hear an oral notice of a meeting, if we can't be in church to receive a printed notice of a meeting, and the church doesn't want to spend 50 or 60 cents per member to send out notices by mail, how do we give a legitimate notice? How do we count the quorum? What's our quorum statement in the bylaws? How will voting be conducted? How will the moderators serve? How will the parliamentarians serve? Most bylaws don't even talk about parliamentarians. You have to recognize, depending on the state, but also federal privacy laws with respect to telephone, cellular phone, fax, text, and email. These forms of contact all require prior written authorization of the individual, the consumer, to receive those forms of communication. In California, we have opt-in requirements, or in other states, there are opt-out requirements. Without prior consent, communication is limited to the U.S. mail and the expense of that. So there are technical and legal challenges that the church has to consider in its bylaws for dealing with these things. Another consideration is virtual meetings can inadvertently omit persons. You have to recognize that there is not a perfect solution for large in-person meetings as a replacement. There are folks that will be technologically deficient. They don't have a computer, they don't have a smartphone, they don't have internet access, whatever it takes to attend your virtual meeting. There are folks that could be disabled that you have to consider. They would be perfectly fine attending an in-person meeting, but they won't be able to attend a virtual meeting. So when it's possible, you want to consider hybrid business meetings where some folks can be together in person while others are attending electronically. Another consideration, how do we make sure that there are no non-members attending or inactive members attending who are voting at the same time? You can use the waiting room feature of Zoom as an example to admit folks only who are members and keep out of the meeting those who are non-members. That's known as restricted admission. You could take a roll call or voice vote, but the potential problem with that is you eliminate the confidentiality of a person's vote. How do you accomplish electronic voting? By email or some other form of technology or via text message? How do we deal with absentee ballots, people who would want to vote on a particular subject but can't be at that particular meeting? These are all things that are challenges when it comes to virtual business meetings. Absentee voting, you have to understand, this is enumerated in Robert's Rules. It's also enumerated in certain ways in things like the Corporations Code. Absentee voting is only permissible when a vote is taken without discussion. And the purpose is to preserve a person's right to be heard on a matter. So it requires delivering a ballot to all eligible persons on request or electronically or by mail. Think of what happened with voting here in California and other places in 2020. They just decided, well, we're just going to send everybody who's a registered voter a ballot, whether they want it or not, without regard to the fact that there are lots of people who are dead on the voter rolls, and those folks got ballots. It's problematic. A way to get around this is to conduct votes that require unanimous consent instead of a majority or a supermajority. But that can be problematic if you can't get 100% of the people to agree on something. Voting to spend or borrow money, other serious matters that are limited to active members. Church discipline is one of those things, or something that would terminate a pastor. Those could very well be so problematic that you have to delay it to a point in time where everybody can be together. You just want to understand that simply authorizing virtual business meetings is not going to eliminate all of the challenges. Unless your bylaws are specific when it comes to authorizing electronic voting during the course of a business meeting, those people that are, especially a hybrid meeting where you have some people together in one room and others attending electronically, that could be considered a form of absentee voting. And if your bylaws don't authorize absentee voting, it's another problem that you have to overcome. If absentee voting is permitted, those who vote by printed absentee ballot or other electronic means, they have to understand that the confidentiality of their vote may not be secure, that totally anonymous voting is not possible in the absentee realm. So what about emergencies? Bylaws sometimes don't address emergencies, and the COVID chaos was one of those emergency things. The term that I sometimes use is called exigent circumstances. And you can address exigent circumstances in your bylaws in a variety of ways. You can give certain church leaders specific authority to act reasonably on behalf of the church, especially when it comes to protecting physical or financial assets, or to conduct other ordinary business without further notice of the church or action on the part of the church. If your church is in Florida, on the east coast of Florida, or in the Gulf Coast of Texas or Louisiana, you may be concerned about the occasional hurricane and the problems that that could cause. You don't need to have a church meeting to decide whether it's a good idea to board up the church windows in advance of the hurricane that's known to be coming, as much as you can simply give the authority to the building and grounds committee or the pastor or the church council to protect the church as necessary in the event of an impending hurricane. Those are the kinds of things that you can anticipate. You know, we talk about anticipating future needs in your bylaws. You can anticipate that by simply giving authority to spend the money without regard to the budget and without regard to a vote of the church, because everybody would, I'm sure, want the church to be preserved rather than damaged. The certain persons, now this is where you need to be specific. It could be the board of directors, it could be the trustees, it could be the church council, another group of trustworthy persons. Ideally, this group is composed of folks elected by the church when we're talking about a congregationally governed church. In a church that's led by elders, it could be the group of elders. The elder board gives themselves the authority to do this. It should not be a single person. Even if that person is the pastor, it's simply not good governance to leave these kinds of emergency decisions in the hands of just one person. Imagine the pastor's on vacation and he's the only person with the authority to make an emergency decision, and you can't get in touch with the pastor. Not only is that not good governance, leaving certain decisions in the hand of a single person could jeopardize the church's tax exempt status if that person does something that benefits them more than it benefits the church. So it's problematic when you leave decision making in the hands of one person. The essential authority to act in an emergency circumstance needs to be provided for in bylaws. More precise statements such as preservation of church assets could be a policy written into the bylaws, but it should be something that you find in the policy and procedures manual, so that you don't have to amend the bylaws every time you want to make that statement a little better than the previous version. This is a perfect example of the synthesis between the bylaws and the policy and procedures manual. The bylaws provisions should specify any limitations on authority. There should be binding under what's known as the prudent person rule or the prudent man rule, in a way that the individuals who are supposed to be making these emergency decisions, if they're negligent in making that decision, or if they make decisions that are unlawful, you could hold them personally and financially responsible for their failure to act. And that's not something that you have to have in bylaws, but it's something that at least says to those folks, if this situation presents itself, you better act rather than not. Carefully written and exigent circumstance provision in bylaws permits authorized persons to apply for loans or grants, something like the Paycheck Protection Program back in the 2020 period, or FEMA funds in the aftermath of a hurricane or earthquake or flood event, without a vote of the church is important. And you don't have to have a business meeting to authorize that action. When it comes to solving a challenge like this, churches that fail to act now, once again, might not be able to lawfully conduct official business if the state experiences another shelter-in-place order. So what can a church do now? You can amend or rewrite your bylaws as necessary. You can adopt a specific parliamentary authority if necessary. Determine what forms of virtual meetings and voting are authorized in bylaws. In-person only, virtual only, hybrid, whatever. You can make those decisions now. One of 4 scenarios might need to be empowered when it comes to meetings: hybrid, in-person, and remote, or exclusively remote, or a combination of internet, telephone, services that integrate audio, optionally video, it's not a requirement, platforms that could interface with texting and voting mechanisms. Another form is simply hybrid or remote telephone meetings, no video, internet services perhaps for conducting votes or sharing documents. Hybrid meetings with a speakerphone in the meeting room to allow members who are not physically present to participate by telephone. Voting under those circumstances would either have to be by acclamation, unanimous consent, or by roll call vote. And roll call vote means everybody is called by name, they give their vote, and everybody knows what a person's vote is. Exclusively remote, telephonic meetings with or without internet support. Again, acclamation or roll call vote. Understand that all 4 of these forms have their own sets of challenges. None of them are perfect. Some people are not going to be happy with whatever method of meeting you choose if it's not other than in person only. What about meeting security? How do you control access to the meeting? How do you keep non-members out? Can 2 or more persons share the same mode of access? Husband and wife, can they be on screen together and casting their votes together independently? If the wife is on screen and you don't know that the husband is off screen pointing a gun at her saying, you better vote this way, those things can be problematic. But it's something that you have to consider in your meeting policy. What if there's a failure of the technology? Some people lose their internet, or the church loses its internet, and people can't continue in the meeting. How do we deal with that? How does the moderator maintain control over hybrid meetings? How do you get access to ask a question? When we meet in a Zoom platform like this, if you tile all the participants, you can only see 20 or 30 maybe on one screen. So if you have 300 people attending a meeting, you've got to have 10 or 15 monitor screens to be able to capture everybody and see that somebody's raising their hand or using the little hand wave icon to attract attention. It's problematic. It's a logistical nightmare. You don't include special meeting or voting rules in bylaws. You use policy and procedures to do that, and you comply with Robert's Rules of Order if that's your parliamentary authority. You simply use bylaws to authorize the kind of meetings that you choose to conduct, but you write your policies and procedures in advance. In fact, both Robert's Rules of Order and state law say that special rules have to be adopted in advance of the meeting. They can be adopted by majority vote, but if you don't adopt those rules in advance and you need to adopt them at the time of a meeting, it takes a 2/3 majority or greater to approve. So it's much easier to create those special rules and have them approved in advance rather than trying to do it at the time. When it comes to policies and procedures, just understand there's no such thing as a perfect policy and procedures manual, just like there's no such thing as a perfect set of bylaws. But without written policies and procedures, you have those pleasant thoughts that we talked about earlier. Altering bylaws always requires a vote. Changing policies and procedures only requires notice to those persons who are affected. Bylaws definitely can be made more flexible by putting the details in the policy and procedures manual. The process for a pastor search committee, how deacons are selected, how you number the number of deacons that we have in the church. What's the current committees? What program organizations? What are their roles? What authority do they have, if any? To do this properly, the bylaws provide the authority in general terms, but then indicate where the details are. And when you do that in bylaws, then it means you have to have the policy and procedures manual. You can't have one without the other. Somebody needs to be in control of the policy and procedures manual. It means physical custody, so that everybody knows who has it. If you need to see the policy, you know who to contact. Can you give me a copy of the policy? And you may recognize this in the dealings that you have in a variety of ways around town outside your church. You go to the doctor's office, they hand you a clipboard the first time you're there, and it says, please fill out this paperwork. And one of the pages in there will be a page that says, I've received a copy of the doctor's privacy practices. It's called a HIPAA statement authorization. And I don't sign that if they don't give me a copy of their privacy practices. And when I turn in the form and they look there, oh, you didn't sign this one. I said, I know. It says that I read and received a copy of your privacy practices. So if you'll be happy to give me one, I'll be happy to sign it. They go, well, we don't have any copies of that. That's like not having the policy and procedures manual on hand. Now, while one person may have custody of the manual, that person should not be the person who also has the approval oversight of the policies. A different person or a different group should have the review and approval oversight. So in a church that operates with a board of directors and a separate church council, the board of directors or one of them could be in charge, that have custody of the policy and procedures manual, or the church administrator could have custody of the manual, and the church council or the board of directors could have approval oversight. We write a policy, they receive it, they review it. If they agree with it, it takes effect. But I want to give you a few examples of the kinds of vague statements that I've seen in bylaws. Something like this: the other ministry teams, worship ministry, youth ministry, men's ministry, women's ministry, and Christian education ministry. The ministry team, as deemed necessary, will create other positions. The basic qualifications, responsibilities, and tenure of the leadership team members are defined as follows. And then it didn't say anything. It just said defined as follows. But it does go on to say the qualifications include born again member. And my comment in the margin was, Well, aren't all church members born again believers? There isn't any other kind. Under deacons, the same set of bylaws. Just reiterated 1 Timothy 3, verses 8 through 13, but then it says in the bylaws that you find this statement at 1 Timothy 3, 18 through 13. Now, that's a typographical error, but is that not a significant mistake? Then it goes on to say the main role of the deacon is to be a servant of all. Well, they could have eliminated all of those qualification things to say the church will have deacons, and the purpose of a deacon is to be a servant of the church. Then it goes on to say, point number 3, the composition, there will be 3 deacons, and the number 3 is in parentheses, and 5 deaconesses with the number 2 in parentheses. Now that's a conflict. That's an ambiguity. Does that mean we have 3 deacons and 5 deaconesses? Or is the 5 a mistake and the 2 is the correct number? This is problematic. And then it says the tenure is 2 years. Now, in good governance, 2 years is not normally an appropriate length of term. In the church, it usually takes a year for somebody in a new role as a deacon or a church council member. It usually takes them a year to figure out what that role is. And then they have another year to serve in that, and then they're done. So you're constantly replacing people that have a year of experience, understanding what it is they're supposed to be doing, and then suddenly they're not there to help guide the new person on the team. So I really like to see 3-year terms because it gives folks 2 years of legitimate service after they have figured out what their role is. Ministry meeting may be held to consider significant matters. A 1-week notice of the subject, date, time, and location shall be given for the specially called business meeting, unless extreme urgency renders such notice, period. Now, that's one of those fragment things that we talked about early on. Unless extreme urgency renders such notice, impossible or going to take a longer period of time, you can't make a statement like that. Here's another conflict, and these are all from the same set of bylaws. The pastor shall serve for an indefinite term, not unusual. If he resigns, the pastor will give at least 2 weeks written notice to the church. The termination shall be effective immediately. Now, which one is it? Is he going to give us 2 weeks notice, or is he going to be gone as soon as he gives us the notice? Or does termination mean an action of the church as opposed to the action of the pastor? So these are the kinds of things that I see in bylaws that other people who write them don't necessarily see. And it's one of the reasons why I offer to do complimentary reviews of church bylaws. And in the last 17 years of working with church bylaws, I've reviewed over 300 sets of bylaws. So statements that are not good governance, ambiguous statements, vague statements, or statements that aren't governance at all, these are all kinds of things that just don't have any place in bylaws that can easily be corrected.
As far as questions, Carolyn was the first in, and she had a couple of questions that all combined. How often should bylaws be reviewed? How long should the review and revision take?
Well, how long the review and revision takes is just dependent on what needs to be done. How often should review occur? At least once every 2 years, maybe 3 years at the latest. I know when I wrote or was the chairperson of the committee that wrote the bylaws for my former church back in 2006 and 7, we actually didn't look at them again for 7 years, and the church had very much matured and gotten on from the unhealthy position that we had once been in. And so it was kind of a significant overhaul of the bylaws at that time, not substantial, but significant. And it took a couple of months to do that overhaul compared to the 6 or 7 months that it took to write the bylaws originally.
Okay, and then Carolyn had a good question here regarding some terminology. So she says, like the words trustee, the words council, the words board. Do those all essentially mean the same thing?
No, they don't. And this is one of those things that you have to be careful about in your bylaws. If you refer to the trustees as a board and you have a separate board of directors, which is not comprised of the trustees, and you simply start tossing out the term board, now you create ambiguity because which one of those boards are we talking about? And a church council could be designated as the board of trustees. It could be the board of elders. It could be anything else. So each one of the, and it's not, I'm not saying that you have to have trustees and board of directors and church council. The corporations code says you definitely need a board of directors. What role you give to the board of directors could be equivalent to trustees. It could be equivalent to a church council. But that's the work of the church to decide how it wants to govern itself. In my model bylaws, I talk about those three different groups, that we have a group of trustees, and whoever the chairman of the trustees is serves as the corporate president. But then we have a board of directors that's made up of the trustees and the church council. And the church council is made up of a group of folks that are elected from the general membership of the church. I sometimes see in bylaws where the church council is made up of all the chairpersons of all the committees in the church. And that could be a council of 20 or 30 or 40 people, which is a council that will be very ineffective because you've got too many voices. So I try and limit or show churches that limiting a church council to, depending on the size of the church, 7 or 9 people is usually a recommended number, so that they can get things done efficiently.
Sherry asks, she says, we don't currently have language to define an active versus inactive member. So if this is something changed in the bylaws, does the whole church have to vote on that, or can the board just handle it on its own?
Well, that's one of those situations where you have to look to the amendment provision in your bylaws. Who has the authority to amend the bylaws? If it says the members must vote to amend the bylaws, then the members are, because you don't have a definition of member, active versus inactive, everybody who is considered a member of the church by whatever standard you consider people members is what you have to go by. Saying this is one of those reasons why a vague statement of membership, everybody who is a born again believer who's been baptized is a member of the church. That could extend to people who don't really attend your church. So what I try and show churches is to create some type of metric that you can use to define the difference between an active and an inactive member. And one of the things that I never do is recommend to churches that membership be tied to things like tithing. You don't want to do that.
Now, I'd like to throw in a question that related to the opening anecdote about the church in Arkansas that will also, I think, be related to a number of the questions that people have, Max. And so the scenario there was, it's a large church, it's 130 years old, things have come to a head. Half of the people would like the pastor to leave, half of the people would like him to stay. They discover they have no bylaws. How does that make a bad situation worse?
Well, first off, it's not a situation that can go to court because the courts are constrained from getting involved in the spiritual aspect of the church. And that's one of the reasons why your bylaws don't need to focus on spiritual elements, because if it gets presented to the church has to say, I'm sorry, we can't deal with this, separation of church and state. The worst case scenario in a situation like this is it's going to come down to violence. Um, it's definitely going to lead to, most likely lead to a church split. The group that is in favor of the pastor, they may leave with the pastor and form a new church, or the folks that are opposed to the pastor staying, they leave and form a new church. Um, what's common in the South, the minister of administration, my former church, tells this story when their church had a similar situation and a split happened. People literally came into the church, and the pews that had the little plaque on it, donated by thus and such family some years ago, they literally unbolted the pews from the floor and took them out of the church, which is highly problematic because none of that property belongs to anybody personally. But that's the opinion that they had. So this is, a church like this without a set of bylaws to govern, they're in very shaky territory, and it's not going to end well for the church, unfortunately.
Right. Yeah. So yeah, it sounds like the bylaws are certainly a legitimate barrier or boundary to the worst expression of human nature, because they provide at least a method for disputes to be handled. Sherry mentioned this. You talked, Max, about disciplinary actions. Should details about disciplinary actions, is that something for the bylaws, or is that something for like a handbook or document about procedures?
Okay, this church discipline is one of the areas where you probably need a very explicit process in your bylaws so that it can't be changed to fit a certain circumstance down the road. And in the sets of model bylaws that I have some pretty detailed stuff about church discipline and how it needs to be handled. If you think, and fortunately, most churches never get into a situation like that. But if you think that there's a potential for a discipline problem to arise in your church at some point in the future, having more details than fewer is going to be a better situation for the church, because it's either going to be protective of the church or it's going to be protective of the member. And I try and be protective of the member as much as I'm protective of the church in the language that I see in the bylaws, because you don't want to favor one over the other.
Sure. Another question is, say you're looking at all your documents, you realize you need to update your bylaws and your policies and procedures. Which one should you do first?
Bylaws. Bylaws are going to be the most complex, and bylaws are going to require a vote. Policies and procedures, you can update those at any time. So if they need to be updated, you just update them. But bylaws by far are the most important to keep updated or review more frequently than policies and procedures, perhaps.
Okay. And then Scott asks, for churches that have no bylaws or minimal bylaws, is there a template? Is there something that you can recommend?
Well, I have sets of what I have put together over time that I call model bylaws. They can easily be customized to fit just about any size church. And I have a set that is designed, like we've been talking about today, for the congregationally governed church. I have another set that's a little more recent that I've put together for churches that intend to be led by elders rather than the congregation, where you technically don't have members of the church.
Are those things that you can make available to people?
Yeah,
Just need to
absolutely.
contact you?
They just need to contact me.
Okay.
And any of the churches that are on today's webinar that have a set of bylaws that want to have them reviewed, I am happy to do that. I don't charge to do that. And you can usually get a set of bylaws reviewed in 3 or 4 hours, 4 or 5 hours.
So I just want to make sure everybody heard. Max said he will take a look at your bylaws for you, and he has templates as well. So
and I'll also work with churches or church committees on revising their bylaws, giving them guidance or assistance.
Okay. Well, that's a very generous offer from Max. Um, Max, going back, we have covered some of this, but it's an excellent question from Carolyn. Said, other than a lawsuit, what are the repercussions of not acting in accordance with your bylaws?
Aside from a lawsuit, it just creates conflict within the church. The big conflict that my former church experienced back in 2001 through 2005 was that we had called a new pastor, and the deacons decided that they really didn't like the choice of pastor, and they fought with the pastor for control of the church. And the bylaws that nobody really had a copy of didn't give the deacons that kind of authority. But because they had been exercising authority that they didn't have, everybody just figured that the deacons had certain authorities. When we rewrote the bylaws, we were very specific to indicate that the deacons no longer had any authorities, that the deacons were simply servants of the church that worked in conjunction with the pastor to do ministry. And the new deacons that were elected when the other deacons left the church were perfectly happy with that, because they didn't want to have any specific responsibilities other than ministry.
Max, Scott also says, if your church has a foundation or an endowment, should that be part of your bylaws?
In the sense that somebody needs to be in a position of oversight over that. It could be the church treasurer because it's a financial asset. It could be the trustees because it's a financial asset. It could be joint authority between the treasurer and the trustees. But yeah, certainly anything specific like that needs to be addressed in some way or another. In many cases, anything that's financial in nature probably falls under the authority of the treasurer. But many times I see bylaws that when you talk about the responsibility of the church clerk or the church treasurer, they're very thinly written. It just says the treasurer will provide regular financial reports. That really doesn't tell anything about the duties or authorities of the treasurer. So when folks look at my model bylaws, they'll see much more specific and explicit information about roles and authorities.
Well, I appreciate the good questions from everyone, and Max, you did an excellent job of concisely addressing those very big questions. My question as we wind down here is: so listening to the full presentation as a layperson, it's a bit overwhelming. All the things that bylaws might need to address, from the topics to the grammatical structure of sentences. It seems like this has the potential to create a scenario of, oh, it's too big, we could never do it, so we do nothing. Do you have any advice on what's a something is better than nothing approach to at least get started?
Well, and that's the situation that you and I talked about before we started the webinar, is that I've worked with lots of churches to start the process of revising bylaws, and then they just don't carry through. That's one of the areas where I can help churches, is to help keep them on track and get things done. Bylaws don't have to be a complicated process, but it takes a handful of folks, 3, 4, 5 folks, to serve on a committee, so that it's not just one person doing all the work, which is what happens in a lot of churches. The pastor says, well, I'll work on revising the bylaws, but then he's distracted with all his other responsibilities as pastor, and it just doesn't get done. So I can assist churches in keeping them on track, keeping them accountable for getting it done. It's better if they have a group of people to work on it, because then they can hold each other accountable. And it's like reviewing the policy and procedures manual. That manual may end up being 100 pages long or longer. And if you say to the church council, you're going to have the review and oversight of this manual, they sometimes get freaked out because everybody thinks they all have to look at the same 100 pages. When you can say to one person, you take pages 1 to 10, another person, you take pages 11 through 20, and so on, and you break it up into small chunks, then it's easy for one person to look at those 10 policies and come back and say, I think they all look good, but there's a couple that we might want to talk about. And it's more efficient, and it can get done once a year or once every 2 years more easily. Same thing with bylaws.
Excellent. Yeah. So some division of labor, and then an outside person like yourself, who can keep the process going when things seems to kind of stall out.
Somebody with experience, somebody that can answer questions when everybody else looks at each other and go, well, what do you think? Or what is this supposed to mean? That's where I can be of great value.
Sure. What do you think about the idea of everyone, the doors are locked from the outside, everyone's locked in a room, and no one leaves until the bylaws are finished?
That's a little draconian.
Slide pizza under the door.
But it in some cases that's what it takes, is to put a deadline on folks and say, if we don't have it done by this point in time, because I served on a pastor search committee that took months and months to come to a decision, because we were being guided by somebody who wanted us to do personality profiles on ourselves and crazy assignments, homework assignments on the committee that didn't have anything to do with looking at candidates and vetting candidates. And it just dragged the process on. And we almost didn't get the pastor that we ultimately chose, because he thought nobody was interested in it anymore because so much time had gone by.
Well, excellent questions. And Max, great insight on a very important and challenging part of church governance. We appreciate you sharing them with us. And Ministry Pacific, the reason that we partner with people like Max is because we want to help churches to succeed. And part of that is minimizing risk of litigation and chaos. And so we appreciate you joining us. Max, any closing words on this important topic?
Just everyone know that you can reach out to me by phone 24/7. I have folks who know that I answer the phone at 1 or 2 o'clock in the morning. If it rings, I answer it. The only time I don't answer is like when I'm on a webinar like this or in a meeting. My phone's been going off and I haven't paid any attention to it. But I will get back to somebody within 24 hours of calling or emailing. And if for some reason I don't get back to you within 24 hours, reach out to me again, because I just didn't see it, or for some reason the voicemail message didn't get to my phone in a timely manner. So
excellent. We'll reach out to Max and to us as well. And we thank everyone for your time. And thank you, Max. Everyone have a wonderful day.